What's up, guys? Igor Hernandez here. I'm one of the attorneys at Cornish, Hernandez and Gonzalez, where I practice injury law and first-party homeowner property claims. And today I want to talk to you about why it does not matter that the person on the other side of the accident, the person at fault, admitted to the police officer that he or she was at fault. And the reason for that is pretty simple. There's something we have in Florida called the accident report privilege. And what that means is that if a police officer is interviewing people in connection with an accident to try to figure out what happened in a non-criminal investigation, because in a criminal investigation, certain things take place that could make the statements admissible. But in a non-criminal investigation, if a police officer is interviewing people for an accident, anything that people say to the police officer is not going to be admissible in court. Not for impeachment, meaning not to challenge their credibility, not as an admission to use against them to show that they were liable. It's not going to be admissible at all. In fact, you could have body camera footage of the person admitting that they were at fault, but that's not coming in either if it was made to the police officer in the process of investigating the accident in a non-criminal fashion. And so often we have cases where the at-fault party admits to the police officer they were at fault. And then we go take the deposition. We're in litigation, we go take the deposition, and the person says, no, I was never at fault. I didn't do anything wrong. I never said that kind of stuff. Well, there's really not much you can do there, because the accident report and any statements that the person made to the police officer will not be admissible in court against that person. So you know they're lying. You know that they're lying to avoid liability, but there's really not much you can do in terms of using that statement against them in court. And so sometimes we get frustrated clients saying, what do you mean they're disputing liability? They admitted to the police officer that they were at fault. And we have to basically explain to them what we're explaining to you, that it doesn't really matter that they admitted, that they admitted to a police officer that they were at fault. It doesn't matter that the police officer wrote it down. It doesn't matter that you were there and you heard it being said to the police officer. It doesn't matter that they gave a full written admission as to what happened to the police officer. None of that really matters. The only time that any of that would be helpful is if the police officer was conducting a criminal investigation and gave the driver what's called Miranda Rights, basically letting them know that anything they say can and will be used against them in court. And at that point, anything they say obviously becomes admissible if the Miranda warnings were given properly. But the point of all that is that rarely happens in a criminal investigation. The only times you see that with not a criminal investigation. That rarely happens in your typical accident case. The only time you see that is in a criminal investigation, a DUI, a vehicular manslaughter, things like that. And those cases are not the majority. The majority of cases are non-criminal negligence cases where there is no criminal investigation, and therefore the statements of the police are not coming into evidence, and you have to deal with that. So anyway, guys, that's it for now. I'll catch you again next time.